10 seconds, 5 seconds. Start. The High Court, by the impugned order in the first paragraph, dealt with the element of the claim of penal interest and opened that the grievances of the bank was baseless, thereafter adverting to the grant of 9% interest towards deposit made by the auction purchaser with the bank, observed that there was no error in the same as the money was lying with the bank. Thereafter, the writ court proceeded to observe as learned counsel for the auction purchaser points out that in fact this interest of 9% is really not full compensation but only part compensation, as liberty has been granted to the auction purchaser to pursue the remedy against the bank, as according to the auction purchaser this property was auctioned by the petitioner bank without even disclosing the factum of the case pending between the owner and the bank in the DRT. We see no reason to exercise our extraordinary writ jurisdiction under Article 226 of the Constitution of India. The learned senior counsel appearing for the appellant submitted that though two issues were raised, yet he would confine his relief to the second one only. The learned solicitor general submitted that if the decision in Rajendra Singh Rana's case, which inter alia dealt with the question relating to the Speaker's power to decide a question in respect of paragraph 4 of the 10th schedule, independent of any application under paragraph 6 thereof, is to be made applicable in the facts of this case. The same would be contrary to the decision of this court in Raja Soap Factory versus S.P. Sharma. The learned solicitor general also made special reference to the decision of this court in Mayawati versus Markandeya Chand and others, wherein it was inter alia held that if the order of the Speaker disqualifying a member was to be set aside, the matter had to go back to the Speaker for a fresh decision, since it was not the function of this court to substitute itself in place of the Speaker and decide the question which had arisen in the case. In addition to his aforesaid submissions, the learned solicitor general also submitted that various substantial questions of law in regard to the interpretation of the Constitution had arisen in the facts of the present case, namely, whether paragraph 4 of the 10th schedule to the Constitution, read as a whole, contemplates that when at least two-thirds of the members of the legislature party agree to a merger between one political party and another, only then there is a deemed merger of one original political party with another, whether in view of the difference in language between paragraphs 3 and 4 of the 10th schedule, a deemed merger is the only thing to be looked at as opposed to a split which must be in an original political party cumulatively with a group consisting of not less than one-third of the members of the legislature party.